Special measures. What are special measures? When a victim or witness reports a crime to the police, they are asked if they'll provide a statement. Sometimes a victim or witness is eligible for special measures. These are things that the court can do to assist the victim or witness in providing their evidence. These have to be approved by the judge or magistrate before the trial. What special measures could I apply for? Number 1. Screens. First, the courtroom is cleared. You'll be brought through the judge's entrance into the witness box. A curtain or screen is placed around you. The usher brings everyone back into the court. Once you've finished giving your evidence, the courtroom will be cleared again before you exit back through the judge's entrance. Remember, you will not see the defendant and the defendant will not see you. However, the defendant can hear you. When using screens, you'll be able to see the judge, the clerk, the jury, the prosecution and the defence barristers. Number 2. Live link at court. This is where you can provide your evidence from a separate room within a court. When using a live link room in court, an usher will be present, along with a witness service volunteer if you require additional support. If you have been working with the IDVA or ISVA and would like their support while giving evidence, make sure the officer knows so they can check with the court. You should only be able to see the person who is speaking whilst giving your evidence. Remember, you might not be able to see the defendant. However, the defendant and everyone else in the court will be able to see you on the TV screen displayed in court. Number 3. Live link from a remote evidence site, RES. This is where you can provide your evidence at a remote evidence site and link in through a camera to the courtroom. A witness service volunteer will be required to attend the remote evidence site with you, just like the live link. If you've been working with an IDVA or ISVA, they can also be in the room with you, but let the officer in the case know so that they can request it when completing the special measures application form. You should only be able to see the person who is speaking to you whilst giving your evidence. Remember, you might not be able to see the defendant. However, the defendant and everyone else in the courtroom will be able to see you displayed on the TV screen. Number 4. Screen the screen. This can be requested when using the live link at court, live link from a remote evidence site, or for a Section 28. You should only be able to see the person who is speaking to you whilst giving your evidence. The jury, barristers and the judge are the only ones that can see you. The screen in the courtroom could be moved, turned off or covered so that the defendant can't see you. Remember, you should not see the defendant and the defendant will not see you. However, if you have done a video recorded interview, the defendant may have already viewed this. If screen a screen is something you want to consider and you have done a visual recorded interview, please speak to an officer to discuss this in more detail. Number 5. Evidence in private. The public gallery is cleared. However, one member of the press is allowed to remain in the courtroom. You will then give your evidence from the witness box in the courtroom. Remember, you will see the defendant, jury, clerks, barristers and judge, and they will also see you. Number 6. Removal of wigs and gowns. Both the judge and barristers will remove their wigs and gowns whilst you give your evidence. Number 7. Intermediary. An initial assessment will take place to see if you need additional support. If so, they can help you to understand and be understood from your interview right through to the trial. Number 8. Aids to communicate. This is an aid or technique that will assist you when giving your evidence. They will stay with you at every stage from your interview right through to the day when you give evidence. Number 9. Visual recorded interview as evidence in chief, VRI. This is where a camera will record you when you provide your evidence to the police. This will cover your evidence for the trial. You will then be shown your visual recorded interview by the officer in the case before the cross-examination takes place. If you use this special measure alone, you will be required to be cross-examined in front of everyone in the courtroom. However, you may consider applying for other special measures if you didn't feel comfortable being cross-examined this way. Remember, the defendant will see your video recorded interview quite early on, and again at the trial. Number 10. Section 28. Pre-trial visual recorded cross-examination or re-examination. To have a Section 28, you'll need to have done a visual recorded interview. The officer in the case needs to apply for the Section 28 as soon as possible. This is so the courts can facilitate all the hearings. One of these hearings may be a ground rules hearing. You won't be required to attend this, but the officer in the case will attend. The prosecution and defence will then decide what questions they can ask you, along with an intermediary should you have one. Next, the Section 28 hearing will happen. This is where you are asked questions by the prosecution and defence. It will be recorded. When you're cross-examined, you will be in a separate room that links to the court so that they can hear and see you. The judge, barristers and the defendant will see and hear you through the TV screen displayed in the courtroom. Finally, the trial will go ahead, where your visual recorded interview and your Section 28 recording will be played to the court. The court must facilitate each hearing of a Section 28, so the trial may happen a significant time after you have done your visual recorded interview. Likewise, the Section 28 hearing is usually some time before the trial takes place. Remember, the defendant will be at the ground rules hearing, the Section 28 hearing and the trial, so they'll see each part of the Section 28 played on the screen in the courtroom. In some instances, although all evidence has been pre-recorded, you may still be required to give a further video recorded interview or attend at the trial should further information regarding the case come to light. You have probably been shown this video as you may be eligible for some, if not all, of the special measures listed above. If you think special measures would make you feel more comfortable when giving your evidence in court, please speak with the officer in the case or your victim and witness care officer. If, at the moment, you feel that you do not require any special measures, that is fine, but just remember to let the police know if you change your mind. In all cases, special measures must be applied for, and the ultimate decision lies with the judge or magistrate. If you have any questions, please speak with the officer in charge, who will be happy to assist.